Okay, so what we wanted to do today was to go over the Act, the major components of a medical cannabis program, and we'll take 3. All right, let's see. Hang on. Directions here. All right, take 3. We'll start over. Take 4, 5, 10, whatever. At this point, so kind of the format for the presentation, we'll go through the elements of a medical cannabis program, an overview of what was given to us by the legislature in February of this year through the Medical Cannabis Act. David Caldwell behind me is going to try to sit there, and he will get up. He's my partner in crime at the Department of Revenue, and I will explain the relationship that we have between the two agencies as we go through this. I will ask that you guys hold questions until the end. It's not my request, it's Mr. Jerry's request for the video, so y'all be mad and heckle him. So quickly to run through objectives of the program. Usually people start taking pictures. We will give y'all these slides. We'll make it easy on you. You don't have to take notes. So when the program went from Initiative 65 to a program that was put together by the legislature, at the health department, we knew that we would have some responsibility for the program in some way, shape, form, or fashion. We didn't know necessarily what that would be, because you guys know how things play out in the legislative session. There can be lots of changes. But we kind of just continued our work on the rulemaking process and looking at other states as we went forward and what they had in their medical programs. So doing that, we worked through some major objectives for the program. Of course, number 1 was to put things in place that were handed to us through the Act itself. So we wanted to make sure that we were compliant with the statute. If you haven't read it, it's a riveting, about 500 pages. So if you have trouble sleeping at night, forget a gummy, just read the Act, and you'll be in good shape. Really, it's a lot of the meat is about the first 100 to 110 pages when you look at it. So we wanted to make sure that we put a program in place that was going to be pretty heavy on compliance. And at the end, I'll talk about individual compliance and kind of regulatory compliance from a business standpoint. So we wanted to make sure that as we were crafting regulations, when you look at the Act, it's pretty prescriptive. It doesn't give the agencies a lot of flexibility in rulemaking. But where we had those opportunities, we wanted to take those and so we could look at everything through the lens of, if we're putting a program in place, how do we make it safe for people? How do we make it accessible for people? And then how do we monitor compliance on the back end? Transparency was a pretty significant piece. There's been a lot of media attention around this. You guys know, you've been talking about it at home. Every reporter wants to know every detail. So we started to look at, when we made rules, we put those out for public comment. Now we did abbreviated public comment periods because the legislature gave us 120 days to put this plane in the air. We're still building the plane, okay? It's flying right now and it's got some Band-Aids, but we're still building it as we go. So we wanted to make sure that we were being transparent and we were relying on those public comments and on that information as we went forward. I think at one point we had an interested parties list of about 3,500 people. I've been in state government 24 years. That's the biggest one I've ever seen. This is probably going to be an issue near and dear to your hearts, is how to prevent drug diversion. So how do we prevent product from going out the back door, and how do we prevent illegal product from coming into the system also? So both diversion and inversion. And then ensuring product safety. The first regulations that we put out were the regulations for testing facilities, because we felt very strongly that product is tested before it goes into the hands of patients and into the hands of consumers. So there are lots of opportunities throughout the process for that testing. One of the biggest requirements is that everything is tested in its final form, that there is a certificate of analysis, and that information is passed on to the consumer also. So the Act, again, this is the Cliff Notes version. It authorizes the use of medical cannabis for qualified patients. On paper, it is not a recreational program like other states have. Now, will our policymakers decide in several years to make it a recreational program? Potentially, but right now they've made the determination that it is a medical program. So what is available through licensed entities. If people are not licensed, they are acting outside of the law. And it's also available to qualified patients, meaning that there does have to be practitioner certification for this. They are based on qualifying conditions, and only qualified patients can access even the dispensaries. So they're not open to the general public. It establishes licensure for the businesses associated with the system, and I'll go over those different types of licenses. Defines our practitioners. This is not just anybody. This has to be a physician, meaning a MD or a DO, a nurse practitioner, or an optometrist. And even their scope is limited. We do include physician's assistants in that also. It establishes the Mississippi Medical Cannabis Equivalency Units. We didn't dream these up on our own. This is actually in the statute, and again, I'll cover those as well. And then I told you guys about the responsibility of the health department. We established a new partner in this process in the Department of Revenue. You know, the health department, y'all know what we deal with. You know, health-related things, licensing hospitals, licensing child care entities, nursing homes, you know, public health issues. We don't collect taxes. They do at the Department of Revenue. So we gained a new partner in this process. Department of Revenue will be licensing our dispensaries throughout the state. Mississippi, you guys know, is the 37th state to have a medical program. So we started to look at all of the other states and look at what they were doing that was going well, but also what was not going so well. And a state that you will hear a lot, you'll hear a lot about Oklahoma and how they do it in Oklahoma. Well, it really is the wild, wild west. I've had lots of conversation with their director, and they put a program out that they didn't necessarily have the framework of safety in mind when they started to implement the program, and they're having a hard time putting that genie back in the bottle. So that's a state that you'll hear referenced a lot. We also look to states to see how we can incorporate different components. People ask us all the time, what state did you replicate? We didn't replicate just one. We're Heinz 57. We looked at what was going well and incorporated that. We looked at what was not going well and tried not to incorporate that. But these are some common components for medical programs. There are typically qualifying conditions that serve as a limiting factor. In our program, there are 20 plus conditions that are spelled out in law that have to be diagnosed and documented by a practitioner in order for a person to be eligible for the program. Practitioner certification, I'll walk y'all through that process so you have an understanding of how that works. Patient registry and the use of identification cards. You'll notice I don't have a big picture of the identification card up there so that everybody can photocopy it and hand it out. Okay, so this is not Monopoly. This is not your get out of jail free. There are typically restrictions on the types of products that can be used. In Mississippi, we don't have a lot of restriction. In some states, a medical program, you can't smoke or vape it. Kind of makes sense from a public health standpoint, but we do allow that in Mississippi. There are pretty strict testing requirements on testing that product at final form. We want to know what pesticides have been applied to the product. We want to know anything that was added to that product either in cultivation or in processing. We're testing for things like heavy metals so that people know what they are ingesting. We're also testing for THC and CBD and the consistency there and the potency there. Reporting into the prescription monitoring program. How many of you guys are familiar with the prescription monitoring program at all? Yay! Just so y'all know, that was more than the supervisors, by the way, so hey. But the prescription monitoring program is a tool that the practitioner can use when a person comes into their office and says that they want to they want to try medical cannabis. The practitioner looks at that condition, they're enrolled in the program, and they believe that they can benefit from the use of medical cannabis. The practitioner at that point can look into the prescription monitoring program and see everything that I'm on. So if I am using benzos, they're gonna know. Okay, if I'm on other medications that there might even potentially be some interaction, that practitioner knows that and has that information up front. On the back side, dispensaries report into the prescription monitoring program. So when there is that transaction at a dispensary, that information, that purchase history goes into the prescription monitoring program as well. There are dispensing and possession limits. That relates to the equivalency units, and we'll get to that. All right, these are the different types of businesses that can be licensed by virtue of the Act. We've got cultivators, we've got processors, we've got disposal, we've got transportation, we've got testing, dispensaries, and research. So June 1, we opened the application system for cultivators, for processors, for transporters, and for waste disposal. Now some of you guys chose to opt out of cultivation and processing, and some as well for dispensaries. So we tracked that information, and so when someone applies, if you've opted out, thank you very much for your application fee and your licensing fee. It's non-refundable, and you should have checked on the front end, right? Because we are looking at making sure that they have their permitting and that they're in the correct zoning. So one of the questions that was asked of me today is, what do people need to realize from this session? Sitting in your chair right now, I would be looking at and thinking about what's my permitting process and what's my zoning look like. So we are in the process of reviewing applications right now. We've got about 30 applicants. Some are about to be approved. And they may be in your location. So practitioner requirements. This is not just every practitioner. Practitioners have to be enrolled in the program because there is some additional continuing medical education that they have to complete before they become enrolled. We've got to make sure that they're in good standing with their professional licensure board. And then there are even some more restrictions on the practitioners in that they can't be part owners of a medical cannabis establishment because there might be a conflict of interest there, and we want to avoid that. We are not making a listing of practitioners available on our website. If practitioners choose to make that information available, they're making it available through the Mississippi Cannabis Patients Alliance. There are some added components for people who are 18 to 25. And what do y'all think? Cat got your tongue, nobody wants to say. They're like, oh gosh. They'll be the ones buying it for minors. There's probably greater risk for misuse, and so there are some more precautions on the front end, all in the vein of preventing some diversion. People who are 18 to 25 who want to enroll as patients have to be certified by 2 practitioners because we're talking about chronic debilitating conditions. For our kiddos, they have to be certified by a physician. And their parent has to agree to be the caregiver for that child. This is probably a biggie right here that we get a lot of question about, that you may have question about, because even if you have opted out, you can still have practitioners in your community who are certifying patients. All right? So one of the things that's very important is that there is a bona fide practitioner-client relationship, meaning we don't want just a doc in a box. Because the conditions that are qualifying conditions for the program are chronic debilitating conditions, there needs to be diagnosis, there needs to be treatment, and there needs to be follow-up. Not just you run in, you get certified, and you run out, okay? So if you hear of instances in your community of, they're passing around these forms for doctors to fill out to certify them as patients, we've gotten those calls already. Number one, that is a lie, because there is no paper associated with the process. So if you hear of that going on, just know fake news, false information. Also, the professional licensure boards, meaning those that regulate the physicians, the nurse practitioners, the optometrists, have put additional regulations in place for those providers, in that the people have to be seen face to face. It's not just a telehealth visit with somebody in Delaware. It's somebody right in the community, in person, face to face. I really strongly advise against getting health care in a hotel, like I've seen advertised in some places. Qualifying patients, we kind of went through this already, but just so you have it. These are the different debilitating conditions. I won't insult you by reading to you, but you know someone who has every one of these. Okay, so the written certification and the process for patient enrollment, this is something that we do get asked about a lot because there's confusion around this process. We have this available on our website also because it gets kind of hard to see up here. But a question that we get most often is, where can I find a medical cannabis doctor? So our response is, you find that medical cannabis doctor, the same practitioner who is treating you for that condition. That practitioner has to be enrolled in the program. So what happens is, when we have a practitioner enrolled, they're assigned a unique ID to our online system. In that online system, they also go in, and that's where they complete their practitioner certification. So there's no paper that's handed back and forth between the practitioner and the patient, or the person who wants to be a patient. It's done through the secure system. So they complete that information. Two things that are available to the practitioner. One, they can limit the amount of medical cannabis that a person receives, and that information is passed from our licensing system to our dispensing system. So let's say I go in and I am only approved for a gram of medical cannabis. Well, the maximum amount in law is much greater than that, but my practitioner believes that I need to start low. I need to go slow, just like I would any other medications, and he or she limits me. So they have the ability to do that. Let's say maybe also I have some chronic lung issues. That's one of my conditions that I'm being certified for. I probably don't need to be smoking it, right? So my practitioner can also limit the form of medical cannabis that I receive. Well, so that we're all on the same page and everybody knows that information is passed from the system to the person's identification card. So just playing this out a little bit further, I'm a medical cannabis patient. I got pulled over for whatever reason. And I decide, I'm going to produce my card. I've got some blunts back here that I forgot about. And this is going to get me out of this, right? Y'all have heard this before, don't act like you haven't. Okay. Well, it would if you weren't limited to only an edible product. So now, I produce on my card, Kris, I can get as many units as I want, but wait, it says right here that I'm limited to edibles. Okay? So I'm acting outside of the law by having product that I'm not supposed to have. Okay? So that's one question that we've been asked a lot by law enforcement. And so that's how we're making that information available. On the flip side of that, when I go into a dispensary, the people working behind the counter at the dispensary also know what I'm supposed to be getting. So let's say, and I pray it doesn't happen every day, but let's say that the system goes down. And we have to rely old school, paper and pencil. Guess what? I've got my card, and they can look at my card also and see what I'm supposed to be dispensed. So that's a question that we get asked most often. This is available on our website if you want to reference it. Yes, ma'am. I didn't catch right in the middle of what you said.
How do you know if the card is authentic if your system doesn't?
Which is probably what we're going to see being sold first. Most of our cultivators right now are most interested in selling flower. We have one testing facility that has applied that they've got to get up and running so that everything can be tested. But you'll see that they start to sell flower first. A gram of concentrate is a unit and 100 milligrams of infused product. Now, if we're talking about an infused product that's going into an edible format, the processors also have to have a license as a manufactured food. I can't think of the noun that's supposed to come at the end of that sentence. They have to have a license for manufactured foods, okay? So we have to make sure that we don't just have Sally Sue in the back putting, medical cannabis in her cupcakes that she sells outside the house. Yeah. Allowable limits for sale to patients. There is a 1 week requirement. We more so look at the 30-day requirement of that 24 units. Y'all all just tried to do the math in your head, didn't you? Let me tell you, it's a lot of cannabis. Possession limits for patients, those do differ from the dispensing units. You can dispense 24, you can possess 28, and a caveat on the 28 is that if it's something that's not consumable, so if it is a topical, if it is a suppository, I can't imagine using that routinely, those don't count towards your possession limits. Allowable forms, just to show you that most forms are allowed. And I have learned of some things this week of even different forms that I was like, well, that's interesting. I didn't realize that you could put it into a drink and have a beverage, but you can. This is really sometimes more relevant when we're talking to more healthcare groups, but there is a part of the act that places like nursing homes, hospitals, your assisted living, hospice, long-term care settings primarily can become a caregiver. Did it just go off?
Do we have an extra battery?
That's not the right one, right? Okay, I'll try to talk real loud. We do have the requirement that they can be a caregiver entity, meaning if you have someone in a nursing home, someone residential hospice, that facility could establish policies and procedures to be a caregiver and to provide medical cannabis to their residents. Now, there is a concern with this because most of these places are funded with federal funds through CMS. They have to meet conditions of participation. As of right now, CMS says this is a no-no. So they are potentially, they could potentially jeopardize some funding, but there are some that are looking at this and they're putting policies in place now to address it. But this is where we get into a conflict between state law and federal law. This is not the only area where we have a conflict. I just said those. So the individual compliance piece. The system that we use to track this is a seed-to-sale system. It's called Metric, and it's just like it sounds. It tracks medical cannabis from small plant form. I'm not going to say necessarily seed, but it tracks from small plant form until the point that it is sold to the consumer in a dispensary. Okay? It is a system that is good. It is as good as the people putting the information into the system. So could I potentially tag one plant and not tag another? Yes, that could happen. Do we have requirements so that there is video surveillance in place? So hopefully we see that that's happening. Yes. But you all know, occasionally people do things they're not supposed to do. That's not going to be any different here. But there are also a lot of people who do the right thing, okay? So it does help us track the product from seed to sale, from cultivator to processor to dispensary. It also tracks if we have product that's put back for waste or if it's taken out of circulation. We can do a recall through the system in the event that there's a bad batch, something doesn't pass testing. We don't want it to get into the hands of the consumers, into the hands of patients. Additionally, it tracks purchase history on people as they go into a dispensary. So every time I go in, it dings my purchase history. So let's say I'm feeling froggy and I decide to go to dispensary ABC and then I decide to go to dispensary 1, 2, 3 because I think, this is how I'm going to get some more. Or maybe I'm just visiting in another town, okay? It tracks that as it goes through the system. From regulatory compliance, it has a very heavy data piece. There is a big reporting component so that we can look at what cultivators selling what, who they're selling it to, the same thing for processors. In fact, we have a data team dedicated to this. So there's both individual compliance and regulatory compliance from a business perspective. So where are we, okay? Health department had 120 days to start licensing people. That's fast, y'all. Y'all know the wheels of state government turn slowly. Well, they were put on overdrive. So the system opened up. We've got about 30 applicants right now. We don't have anybody who's quite over the finish line yet. There's some pieces that still require some due diligence on our part. Things like making sure you don't owe taxes to the state, making sure that you've got your background check information, and then there are about 20 standard operating procedures that they have to submit. So we know that it's a legitimate business and you know what you're doing. So that is underway. We routinely put out frequently asked questions on our website. There's a page that's dedicated to medical cannabis, and so we direct people there a whole lot. July 5th, I don't want to steal your thunder, David, but July 5th, the Department of Revenue starts taking applications for dispensaries. That is going to be so much fun. I'm going to leave that up to him to talk about because there are some things that are unique to dispensaries and their application and licensing. And then I included our generic email at the bottom for you if you have questions. We check that religiously. We try to respond within 24 hours. If we don't get you within 24 hours, I promise it'll be the next day. And y'all can hear me again. So, the question in the back, how do I know a card is active? So we are building a handy dandy portal on our website for you to be able to go into with restricted access for law enforcement to access and see if that card is active or not. I can tell you that right now we have no active cards. We're not going to have any active cards until we know that there is legal product available. So we are approving people for the program. But we're kind of like State Farm. Y'all know how they send you your email and you can go in and print your own card? Okay, same premise. They get a PDF version. But right now, they don't get access to that yet. So they're getting approved for the program, but they can't activate their card. And the reason for that is we don't want people to have cards, to have that access before we know that there is legal product available to them. When we see that we have dispensaries that are starting to sell, then those cards will be activated. So all of that process is evolving right now. David, you want to talk about dispensaries? I promise I'll get you questions. He asked us to hold them to the very end. We're going to give y'all time.
Thank you, Kris. And I have no slides whatsoever, so I'm going to be super quick. Right. My name is David Caldwell. I'm an attorney with the Mississippi Department of Revenue. I wear a few different hats. One of them is that I represent ABC. So Kris is going over all these different things that the Department of Health is required to be over, and that's pretty much everything, except for really one thing, and that's dispensaries. The Mississippi Legislature put ABC, through the Mississippi Department of Revenue, in charge of dispensaries. And the reason is because there is only one controlled product that's been sold for probably about 70 years in Mississippi. That's alcohol. Okay, that's the way we regulate it. So in this way, medical cannabis is going to be treated in much the same way when it comes to dispensaries. ABC local law enforcement will be the ones who's enforcing all of those laws. If you have any issues related to dispensaries, your local law enforcement can contact their ABC district agent for cooperation and any type of investigation help that they need. So generally speaking, the way that dispensaries are set up is to act as the end point, right? Kind of the face that the public will see whenever they're buying medical cannabis. So who can buy it? The only people that can actually buy from a medical cannabis dispensary are those people who have a patient card. If you don't have a patient card, you cannot buy anything from a medical cannabis dispensary. You can go inside a medical cannabis dispensary, but you can't buy anything. If you're under the age of 21, you cannot go inside that medical cannabis dispensary unless you have a patient card and you have a legal guardian or your parent with you. Okay? So that's something else that ABC will be checking, maintaining, kind of similar again to what the package stores are. One of the integral parts is the seed to sale. That's something that the dispensaries will have to maintain records on anything they sell, who they sell it to, that type of thing. That's another thing for your local law enforcement to keep in mind. They're required to maintain those records. Those records, in certain circumstances, would be subject to subpoena as part of an investigation by local law enforcement. So those are some of the things that we thought of when we were really trying to figure out how are we going to regulate this, but also how to make it so that patients who truly need medical cannabis for relief can also get a safe product, right? So they know what they're getting is what they're actually paying for. In terms of where can a dispensary be located, it has to be a separate premises, okay? So, you know, whenever you walk into a gas station and up on the side, on one side, are like all those weird herbal pills, and then you got Jewel over here, that can't happen, okay? Now, can you have a strip mall with a gas station and a medical cannabis dispensary right next to it? Absolutely, you can. As long as they have separate premises, they don't have a shared interior wall, or entranceway, so that's fine. I think one of the biggest issues that we are seeing, though, is the Mississippi Legislature placed one requirement when it came to dispensaries that is unique and no one else has to deal with, and that is a 1,500-foot restriction, which means that the main entranceway of a dispensary can't be located within 1,500 feet of the main entrance of another dispensary. That means that we have certain type of time pressures that the Department of Health does not have to go through, because on July 5th at 8 o'clock Central Morning Time, everybody's going to be logging on to get that dispensary permit, okay? And we're aware of that, and we've got a system set up that is fair, that is equitable, and is a first-come, first-served kind of basis. We also, on our website, we absolutely piggybacked off of Mississippi Department of Health on this. We have a checklist up. We just put up a video yesterday that is kind of a point-by-point, how do you apply for a medical dispensary. We've been inundated with very good questions. I've actually gotten a few while I was sitting up here to make sure that everyone has good information out there. Are there any particular types of questions that y'all have? Because that's pretty much all I have to say on that.
The dispensary is only like packaged liquor.
It will be, we are absolutely not having medical cannabis that is sold recreationally, okay? But again, in terms of the way that ABC is looking at medical cannabis dispensaries, the way it's regulating it is very similar to a package store, if just at a more heightened level. Because that's frankly something that has worked well in the past. It works well for the business, right? But it also works good for the communities to have a very tightly regulated, restricted sale, which is what most places have when it comes to package stores. Yes, sir.
What was the thinking in not having pharmacists and pharmacies distributing medical marijuana, since this is a medical product,
Sure.
as opposed to entrepreneurs with no medical background?
Okay, so the question is, what was the thinking behind not having pharmacists involved in the actual dispensing
Right.
of medical cannabis, and instead allowing entrepreneurs? And that question is so far above my pay grade, I could not even tell you. We are the will and pleasure, and we will certainly enforce the statutes and the bills that we are provided by the Mississippi legislature. Okay? Yes, ma'am.
Something was mentioned about CMS, and federal laws that way. Am I to assume that, managed care organizations like Medicaid and Medicare will be,
Tell her to repeat the question because we can't hear it.
medical marijuana, how about commercial?
Her question is basically, will insurance cover medical marijuana? No, that is strictly prohibited in state law even, that it cannot cover medical marijuana. Sure.
Is it regulated as a drug or as a tax? Marijuana.
So medical cannabis sales are subject to 2 different taxes. The first is, I'm sorry, I apologize, I just got heckled up on the front. The question is, as I'm taking it, what type of taxes are applicable to medical cannabis sales? Is that fair?
Pharmacy has those subsidies for sale drugs. Anybody without any student can sell or want it as a drug or taxable item.
Okay, so he is asking a somewhat philosophical question as to whether or not it's a taxable item or it is a drug for sale. I can only say that the bill is set up so that there are 2 taxes applicable to it. One is a 5% excise tax is paid by the cultivator on the first sale to either a processor or dispensary. The other is a 7% sales tax, which incorporates all sales tax law into the sale of the medical cannabis and medical cannabis products. Yes, ma'am, I believe you had a question.
I have two.
she's got
The
two.
original bill, it was supposed to be in-state only, people opening dispensaries,
Mm-hmm.
and that's been changed.
So the first question was there a change on a first draft of the bill where only in-state citizens were able to open dispensaries?
Yes.
As far as I know, the in-state residence requirement is only good for 1 year till December.
Till December.
And that only applies to everything except for dispensaries.
Right. So the in-state requirement for ownership applies to cultivators and processors. Cultivators and processors have to have 35% Mississippi ownership until the end of the year. If they are a micro cultivator or micro processor, smaller, more like craft breweries, then they have to have 100% Mississippi ownership until the end of the year. There's significant legal challenge there, but it's only in place until the end
But
of
the
the year.
dispensaries are anybody.
Dispensaries or anybody.
Okay. And then you said that if you had a card, no, you didn't have to have a card to walk into the dispensary.
As long as you're over the age of 21.
So anybody could just walk in and look around.
So the question is, can anyone walk in and look around as long as they are over the age of 21? That is correct for dispensaries.
Okay.
Yes, ma'am.
What's the fee for an application?
What is the fee for an application? Is that for a dispensary?
Yes.
Sure. So there is a $25,000 annual license fee as well as a $15,000 application fee.
Thank you.
Whoa. So we're not getting rich at the agencies on those fees, let me note that. Those fees go directly to the general fund and they have to be appropriated by the legislature, even for us to run the program.
Since y'all were that specific about fees for the state, why is the legislation so vague about fees municipalities can charge? Because it essentially says you can charge a fee, but you can't charge a fee that's appreciably different from fees you may charge other businesses. That didn't make any sense. You could have just said, hey guys, charge them $1,000.
Sure. So the question is, why is it that the bill is vague when it comes to what municipalities or counties can charge for a fee when it's very specific on what the state can charge? I don't know. That's what the bill says. I apologize.
What can we charge?
That's certainly a great question for your county or city attorney to speak to them or an AG opinion. Yes, sir.
Could you speak to any specific security requirements for dispensaries, like vestibules or anything that might be requested?
Absolutely. So the question is, any specific requirements for security when it comes to dispensaries? Within our regulations, that was something that we have very specific requirements for. Well, ranging all the way from the type of camera, how good the coverage has to be, what placement there is, what it has to cover, down to the alarm system, who can be in at what hours. Now, there's actually a number of different things that local governments have quite a bit of control over. One of them is the hours of sale. I mean, y'all can set the hours of sale. So that's something where, as part of the operating plan, the applicant has to list what their operating hours are, right? And that's based on the ordinances passed by cities. Yes, sir.
Yeah, I'm speaking on the ownership. I didn't hear you quite clearly.
Was there a specific thing? I really didn't.
Well, I was trying to find, you saying that like some business, you have several people in ownership of it. So are you saying that one person had to have that ownership when it comes to, or can they have a corporation and ownership?
Sure. So the question is, what type of corporate and ownership structures can be in place? And I think if you'll look at our regulations on the website, it goes into what constitutes an economic interest, because that's what we're concerned about. So if you'll go to that and read over it, because it's a good little list, we try to provide really good guidance. But the short answer is, you do not have to be a 100% owner to be the eligibility for, meet an eligibility requirement for a dispensary. You can be an LLC, you can be a corporation, you can be a partnership. Pardon?
So growers and cultivators, I think what you were asking is about the Mississippi residency requirement. And right now it's 35% Mississippi ownership. And so that can be people, that can be an LLC, that can be a combination of the two.
At least 35.
Yes, 35% or greater, yes. Has to be at least 35% through the end of the year. At the end of the year, that changes and that requirement goes away.
David, what about signage at dispensaries? Do the cities get to totally control how they display their signs, or is that something y'all are involved in?
Okay.
Big marijuana, I mean, what happens with that?
So the question is, how much control do local governments have over signage? First, I would say the Mississippi Department of Health has put out really good regulations when it comes to signage, what can and can't be done. That would also apply to dispensaries. The Department of Revenue incorporated those signage regulations by reference. But yes, I believe there is an allowance within the bill for local governments to control signage, that kind of thing. I will say that actual enforcement of those ordinances would be a local thing.
Does it also control how many dispensaries? So it's 15,000 or maybe 1,500 per month.
Sure. So the question is, can local governments control how many dispensaries are actually located in the town? Mississippi chose not to go with a cap model. It's not like Arkansas, it's not like Alabama, where there's an actual cap. I think the Mississippi legislature wanted to go with a more free market approach. But what is in place is that a dispensary can't be located within 1,000 feet of the property boundary line of any church, school, or child care facility, as defined by our regulations, which if you've ever been to a Mississippi town, narrows the amount of places it can be. Then when you add on the 1,500-foot main entrance to main entrance prohibition, that narrows it even more. Yes, sir.
You know, I wish we just had some quick bullet points of what the city can do. For instance, can the city restrict placement based on zoning? Can the city actually go through a process of reviewing the various applicants and having some control over which one gets a business permit and which one doesn't?
Sure, that's a great question. Generally speaking, his question is, what type of control does the city have over where dispensaries can be located, that kind of thing? First, I would suggest that you go to the Mississippi Attorney General's website to go into their opinion section. There was an Attorney General opinion issued on April 14th of this year that discusses some of those issues. So that's a good place to start. Second, generally speaking, the bill does provide that localities can have a local business permit that can be issued, right? So that is certainly something that if you feel comfortable, based on advice of counsel, to restrict in that way, you can certainly go that route as well. But some of these are city issues that are up to the cities. Yes, ma'am.
I just want to ask, when an applicant fill out the application, is that guaranteed that they would get the application, or is that any fees withheld from that amount of money, about $40,000 is what you're saying?
Sure.
And so is there any fees withheld?
The whole fee is
So-
non-refundable.
If you're not approved for that application, the entire fee is withheld.
The question is, what portion of the fee is refundable? Now, at least for dispensaries, there are two types of fees. Remember, there's the $25,000 annual fee, there's the $15,000 application fee. At least when it comes to the $15,000 application fee, the only place the bill allows for that to be refunded, it's specifically referred to as non-refundable, except when the dispensary is rejected or denied a permit based on it being within 1,500 feet of another dispensary. So in that case, the $15,000 fee would be refunded. Yes. Yes, sir.
When your local dispensaries offer delivery service in your community?
The question is the local, sir, just 1 second. Hold on 1 second. I'm sorry. Can a dispensary offer a local delivery service? No. By the bill's own language. There's no such thing as delivery. There's no such thing as drive-through windows. There's no such thing as internet sales. Any
No
of that.
curbside.
No curbside. So that's specifically stated. Yes, sir. I'm sorry, repeat that question?
Dance studio.
Is a dance studio considered to be a school? So that would probably be a fact-dependent determination, but generally speaking, I would not consider a dance studio to be a school. But it depends. That's something that we would have to review as part of the investigation process. Yes, sir.
You just want to know about when y'all getting ready, they're going to blow the doors up and get permits. But which comes first? The municipality issuing a business license or a permit, whatever you want to call it, before or after y'all issue y'all? Which comes first?
Sure. So the question is, what's going to come first, the municipality issuing the license or the state issuing the dispensary license? It depends. Generally speaking, it will be the municipality will issue their license first. However, we do have some instances where cities have said, we're not going to issue our license until the state issues your license. It's like a chicken egg kind of thing, right? So in return, what we've done is we put a statement for the applicant to fill out under oath that basically says, I can't get a permit right now from the city because either one, I can't get one till you give me one, or two, they're not going to start getting out permits until later on this month, okay? So they submit that. Now, the bottom line is, though, they cannot have a state permit unless they are granted a city permit, assuming that there's a city permit being issued. So if at any time we receive word that the city has revoked a permit or denied that permit, that's grounds for revocation of the state license.
Hey, David, I promised the lady in the peach I'd come back to her.
Okay, guys, we have time for about 5 more questions at their,
Okay, so my question on law enforcement, you touched on it earlier. So if an individual has medical marijuana in the car, and they're transporting the marijuana from the dispensary or wherever to their home, and they get pulled over, again, you referenced earlier that they can only have a certain amount. You said that edibles is the. Now, explain that to me, because in our town hall meeting he made a comment, because we really didn't know what the laws were gonna be. You know, it's kind of like prescription medicine, you're not blind taking this. So if somebody has it and they're transporting it, they get pulled over and they show the card, does that make it legal in the eyes of law enforcement?
So her question is, if a person's transported and they're on their way home from the dispensary to their house, and they get pulled over, is it legal? So let me tell you what they want to look at. Your law enforcement officer wants to look at the card, wants to look at the bottom of the card to see how much they're supposed to have and the form that they are supposed to have. If it's outside of that, then it's not legit. If it's not limited in any way, then if they have it, it's packaged properly. However, if they're impaired, that's a whole other issue.
There's no open container law for.
Does he look at, he or she look at anything that says, if you cannot use this online? I mean, I don't know how.
Oh, you're not supposed to use it while you're driving, period.
If an officer pulls you over and he suspects you of.
Okay. All right, one more question. How much are y'all bidding at this point? I'm kidding. I don't care. I'll answer the healthcare question.
As a healthcare provider, are there any tracking systems for the department to track, is a certain healthcare provider issuing more than the average?
Yes.
Because there was not a lot of regulation or checks when the opioid crisis of providers. DEA didn't do their job, and neither did the state level do their job, and now we've got an epidemic. So how do y'all track healthcare providers?
Her question is, how do you track the providers? And I think what you're really getting to is how are you able to identify a bad actor?
Exactly.
I just kind of call it like I see it. Okay. So within the system, when I talked about individual compliance, it's also individual compliance for practitioners. So if I'm writing a lot of certifications, I know how many, and I know what conditions the person is writing for, and we share that with their professional licensure board to take action on if they need to. For example, we've got 3 right now that are writing them, and I can tell you exactly what they're writing them for. So yes, ma'am.
When business licenses are applied for, whether it's cultivated or whatever, are they location specific?
Hey,
Do they
Dave,
have to put
let's
in
be
there?
respectful.
Do they have to put in there, I intend to operate in blank?
Yes, his question is, when businesses apply for licensure, are they stating their locations? Yes, absolutely they are.
So y'all know if someone has applied for a business license in my community?
Correct.
Will you tell me?
Sure.
Okay, thank you.
All right, last question. His question is, can you bring a prescription from another state? There is a provision in the law for temporary patient status, essentially, and it limits it to 2 15-day periods that a person can be here, and we will take the card. Basically, it's reciprocity. We'll take the card if it's a medical program in that state. They have lower possession limits, lower selling limits, and they can't go over 2 15-day periods in a year.
Could you explain to them where they can get the slide, or if you have something, and we'll get out of here for the
Yes, we will get the slides to you guys. We'll send them to the MML, and then also check our website, which is healthyms.com, and all of this information is there also.
Let's give our presenters a hand.